All right, folks, I think we will go ahead and get started. If I could, before we get started, ask everyone who's joining virtually to please remain on mute unless you are offering comment today. That would be much appreciated. Good afternoon and welcome to the Rules Advisory Committee meeting for the OLCC's 2025 Cannabis Legislative and Technical Rules Package. Thank you everyone for taking time out of your busy schedules and on a beautiful day to attend today's meeting. My name is Nicole Blase and I am the Rules Coordinator for the Oregon Liquor and Cannabis Commission. I'll show my face just on my camera so everyone knows who I am. Hello everyone. Okay, a few housekeeping notes before we get started. Of course, today's meeting is being recorded. Again, please ensure that your phone or computer are muted unless you are speaking. Only invited committee members will be a part of today's conversation. Members were selected due to their level of interest or position within the community. With that in mind, we ask that each of you serve as goodwill ambassadors to the discussion so that you may represent your constituency professionally. Please be courteous to other committee members so that we do not have multiple participants speaking at once. You may use the raise hand function in Teams, or if you are calling in, please interject when appropriate and we will call on you in order. Letting a few folks into the room. Committee members, please state your first and last name and affiliation when you are speaking. All right, let's go ahead and get started. Today is Tuesday, September 16th at approximately 12:03 p.m. Many of you are not familiar with the rulemaking process, but for those of you who have not yet had the opportunity, or for those listening in, I will begin by saying a few words about rulemaking and the purpose of advisory committee meetings. The purpose of an advisory committee is to increase the public's involvement in the drafting and development of administrative rules. The Oregon Legislature, through its enactment of the Administrative Procedures Act, ORS Chapter 183, stresses the critical importance of the public's participation in policy development. Advisory committees are an excellent way to solicit input from internal and external stakeholders who are likely to be impacted by the development or amendment of agency policy and rule. Advisory committee invitees may include licensees, permittees, industry representatives, OLCC staff, members of law enforcement, local government, the public, and local community organizations or other interested stakeholders. Our commission strives to hear from all interested parties and industries who may be directly or indirectly affected by the rule package that we will be discussing today. Our role is to explain the background and context of these rules and the changes that are being proposed in this package. We will provide facilitation to ensure that all committee members can provide input today. Under Oregon's public meeting law, this meeting is open to the public, and the public are free to observe our discussion but may not offer comment. Non-committee members will be able to tender comment during the public hearing and comment period. Again, the agency is recording this meeting and will post a recording of this on our website after the meeting. All right, we are here to discuss the 2025 Cannabis Legislative and Technical Rules Package today. The Oregon Legislature passed several bills during the 2025 Oregon legislative session, which require agency rulemaking to implement, specifically Senate Bills 162, 558, and 907. Further, the agency must also undertake rulemaking to respond to changes within the industry and consider whether technical adjustments are necessary. And we will go ahead and do introductions. Again, for RAC members, please state your name and organization. Again, Nicole Blase, Rules Coordinator with the OLCC. And I'll just have the OLCC staff, we have a lot here today joining us, but those that are directly participating in the conversation today introduce themselves. Amanda, you can start. Rich.
Rich Evans, Public Safety, OLCC.
I'm the Board Director of Education Policy, OLCC.
Steve Bradley, Cannabis Policy Analyst at OLCC.
Jenna Old from Oklahoma County Health Department.
Go ahead and go around the room. Thanks.
Cat experts.
Deputy Massey, CDC dispensary.
Caitlin Moore, Nectar Markets.
Ellisburger and Merspaugh Group.
Erin Bridget Brandon.
Marissa Rodriguez, Noble Distribution.
Jesse Bonke, Executive Director of the Cannabis Industry Alliance of Oregon. West Rivers Alcohol and Drug Policy Commission.
Great. And are there any RAC members that are joining us virtually today that would like to introduce yourselves? Go ahead, Josh.
Josh Kelleher, with Just Jays and Optic Realty.
Thanks, Josh. Marcia?
Marcia Bontrager. I'm not currently working in the cannabis market, but I have managed a few different dispensaries around the state.
Great. Thanks, Marcia. See anybody else? Rhea and Lee?
Lee Stewart, Big Village Substance Use Prevention Coalition.
Rhea Miller, Millerville Farms.
Thank you. I think that looks like it for the RAC members. Okay, let's go ahead and get started. I will turn it over to Steve and Sally.
Thanks.
Sorry, before you get started, I just want to let everyone know who hasn't joined us. We're going to go through all of the draft proposed language first. We need to get through that first, and then whatever time we have left over, more than welcome for general questions and discussion. Go ahead, Stephen.
Yeah, so we have 3 bills to implement, Senate Bill 162, Senate Bill 558, and Senate Bill 907. Great. And then in addition to implementing those bills, we have about 10 technical clarifications that are included throughout the rules. So I think the easiest way to do this is just going to be to go through the draft language sequentially, and we'll discuss concepts as they come. So the first concept to discuss is on page 3, OAR 845-025-1030. This is implementing Senate Bill 907, which requires notarized consent from the property owner for the property where any producer or processor license is located. And that's both that initial licensure, and we'll see later in the rules that it also applies annually at renewal unless the consent is explicitly given for a multiple year period. So the language here, I think, is pretty straightforward, deleting the previous language about property owner consent for producers and replacing it with the new language that applies to both producers and processors. Any feedback on this language on page 3? Go ahead, Lynn.
I heard that you stated it. I just want to make it explicitly clear that this is requiring notarization unless explicitly stated in the original lease contract that is notarized, that it can be, that stands for a certain number of years.
I don't want to speak for our licensing folks, but my guess is that a notarized lease might not meet the exact language in the bill because it talks about the applicant or licensee going and notifying the property owner of the intent. There's some really specific language in there. I think we'd have to look at those on a case by case basis. But if the owner of the property is the licensee, then the requirement doesn't apply. And if the notarized consent is given for a multiple year license period, then new consent isn't required annually until that specified period expires.
Okay, thank you.
Yes.
Is the form that is required to have the notarization on it something prescribed by you guys? Or if a lease includes a clear declaration that the property is to be used and the lease is notarized, does that count? Does it have to be a separate form? And
Licensing, it's how you're handling the actual documentation.
We have not had a thorough discussion on that. In the past, we have allowed, if it specifically calls out in the lease that they can produce marijuana on the premises, we would allow that. But with it now having to be notarized, we haven't really had those discussions yet. So any feedback you guys can give us would be great.
obviously, the less forms that people can have, the better, especially if a form is a normal part of doing business, right? Like, this is a lease, the owner has to sign it, and I think that's the other thing is can a leasing agent who's representing an owner sign, like, have it signed and notarized, is that good enough? Do you actually need the owner of the
The property
property?
owner.
And all of them, or just one of them? How do you deal with things when there's more than one owner on a piece of property? Obviously, we want this to be as simple as possible. I will say I'm not super excited about this bill. And, you know, there might be some good intentions behind it, but this could really complicate people's things, especially with hard deadlines. So the other thing I guess we'd ask is if we are really forced to face this, that we make sure that there's enough flexibility that if someone is not able to get a proper document due to no fault of their own, that they're treated with kindness and flexibility in relation to their licensing, that they don't just get shut down or given an opportunity to try and adjust it. Obviously, good faith actions are necessary, but you know, I can see this becoming very complicated very quickly.
Yes, and that is something that we thought about as we were crafting these rules, so we'll get to it later, but there is language equivalent to what we have for the tax compliance certificates for retailers to allow extensions while working through those kinds of issues when a licensee is renewing.
Yeah, I just had a comment that kind of similar to Jesse's. I had a situation where the property owners, there was one person they were all family and did not speak to each other. And one just didn't want anything to do with it. So yeah, it sounds like you may have covered that, but just know that, yeah, like sometimes they're the representative of the family that does it, that one representative could be in control of that. Is because I think the issue that came up is that there was more names on the deed, but had nothing to do with the actual business of renting the property, just a lived experience.
It's,
I think there might be some concern in regards to maybe like a foreign owner, with different, you know, time zones and different, language barriers perhaps. As well as, you know, a simple landlord tenant dispute could spiral into an organization losing their license rather than being able to resolve that separately. And being tied to that may very well cause some people to lose their license simply because they couldn't agree on frontage or trash or something else.
thank you for the feedback, and yeah, this one, our hands are.
We understand that you're responding to the statutory language of 907, but
having
to the greatest degree possible, providing that flexibility to be good.
Absolutely.
And for all the cannabis licensees in the room, could you raise your hand if you are concerned about how this may affect your business?
It looks like Josh Kelleher virtually has a question. Josh, go ahead.
I just want to say that I agree with Jesse that I think this is going to get complicated really quickly, especially with multiple owners on properties all over the country. We see that quite a bit, especially if it's going to be required year over year. That's it.
Thanks, Josh.
All right, any further feedback on 907, or at least on that language on page 3? So next change is on page 6, staying the same rule, also implementing 907, and this is just clarifying that for an application, if no documentation is submitted to meet that requirement, then that application is incomplete.
Josh, did you have another question?
No.
Okay, thanks. Go ahead, Stephen.
Any feedback on that? And I guess just the distinction being if nothing is submitted, then that application is incomplete. If there's questions about whether the documentation that was submitted meet the requirements, it's something that would be worked through between the applicant and their investigator.
But the only change there is that the property owner informed consent requires notarization of that.
Yes.
Okay.
All right. Next change, page 7. This is again more of the language implementing SB 907, the notarized consent. The bill specifies that OLCC has to independently verify the ownership of the property where the premises is located or proposed to be located. So we have reflected that in the rule.
As somebody who processes a ton of these, can you just elaborate on what independent verification means so that we can set the expectation with our clients and their property owners and
Sure, I mean, it's typically just checking the county property records where the property is located to verify ownership on file with the county.
okay, so this is just a digital record search, the name on the notarized form matches the deed.
Yep.
Good deal, okay.
All right. Oh, yeah, go ahead, just.
Could you like put that specificity in, like, that you guys will like that?
So not every county manages their property records the same way. I don't know
Okay.
if we could get that level of specificity. Next change, moving on from the property owner consent to SB 162, which changed the language around schools. A few years ago, SB 1522 in 2022 changed the language around proximity to schools so that a retailer could not be within 1,000 feet of a kindergarten or pre-K provided by a school district or ESD. This year, SB 162 basically unwinds that previous change. So kind of throughout the rules here, we'll be deleting the language about buildings where public pre-kindergarten and kindergarten programs are provided. So this is just resetting the retailer proximity to school language to the 2022 standard.
I do understand, is it, so I do understand that was the change made at the legislative level. But I would like to know why that was crossed out, because we do have concerns in our county. There is 219 preschools listed on Preschool Marketplace. Those are run with public funding from state and the county. So, and I just see that like the ones that are run by school district and educational service district do count, but those are only 28 of them.
Yeah, so I mean, I can't speak for the legislature. I do know there was some challenge with actually identifying where the schools, the pre-K and kindergarten programs that this was subject to were located. You know, we talked to other state agencies, and basically it did not appear that anybody had a complete list of what those affected pre-K and kindergarten programs were and where they were located. So that was a challenge in implementing it before, but in terms of this rule change, we're simply striking the language because that's what the legislature.
Yeah, I understand. It is surprising to hear that there was no official list because I could see the map. Like there's an interactive map. People can go on to find the locations of the preschools in our county.
Is that just a Multnomah County or is that?
It's Multnomah County.
Lee, do you have a question or comment?
Just a comment building upon the one that was just made, because I understand there is a difficulty in terms of registering the different types of programs and mapping them, but it does seem like one that could have been resolved had the proper people been involved with it, because research has shown that buffer zones help protect kids, and Oregon has some of the least amount of buffer zones, or limited, and some of the most highest density. Washington, in comparison, they include playgrounds, public transit centers, rec centers, childcare, public parks, libraries, and game arcades, basically anywhere that kids hang out. And a comparison of the two student surveys between Washington and Oregon shows that Washington students have a much higher perception of risk than Oregon students, which is important in prevention science in delaying initiation of substances. So I just want to say also that if this is something or going forward in the future, because I know it's a hardship for dispensaries that have already located in those zones, but perhaps in the future we could grandfather them in and then expand upon the buffer zones to better help protect kids.
Thanks, Lee. Any other feedback on this change? All right, so the other change on the same page is more implementing SB 907. So adding the denial criteria for denying a license if the notarized consent documentation that is submitted doesn't meet the requirements, or because it's in the bill, if the commission is not able to verify the ownership of the proposed licensed premises.
Alex Berger, I have concerns about this, Stephen, because my understanding is that it would not be a denial. It would be an incomplete application. And so there would not be contested case hearing rights. Yet it's not in the licensee's control whether commission can verify the ownership of the proposed license premises. So I would think that there should be hearing rights allowed so that a licensee can verify the ownership of the licensed premises.
Yeah, and so this is in the denial criteria. This is a commission must deny if these conditions are met.
Oh, so there would be hearing rights.
Yes, there would be hearings.
Is that the same in the renewal language?
So the distinction is if no documentation is submitted, then that is incomplete. If the documentation doesn't meet the requirements of the rule, then like so here, if it doesn't demonstrate the owner of the premises consents to the use of the premises for producing or processing, that is a denial basis. So there are both conditions where an application would be incomplete and conditions where the denial criteria would apply.
And it's the same for either initial application or renewal?
Yes.
I know it's Jesse Bonnick, UCIO. I know it may not be the biggest thing, but if someone's denied because the OLCC cannot complete its responsibilities, I feel like the bare minimum, any fees they've submitted for that should be refunded. There's nothing that they could have done differently.
I agree, especially for a renewal application where you have to pay the entire fee.
Can I agree?
Yeah, that's a good point.
We'll make note of it.
And by the way, I would just say the same goes, I mean, whether or not OLCC can verify the ownership, some licensees may not be able to get from their landlord a signed notification.
Right. Yes, that is a concern, but within the framework of the statute, I don't know that there's a pathway around that other than, as Jesse said, making sure to build in as much grace as possible in the process. All right. Next proposed change is on page 11. OER 845-025-1115. So these are denial criteria. This one is proposing to remove the prohibition on having producers under common ownership located on the same tax lot. The history of that language goes back to 1991, where the premises was defined as the entire lot where the proposed operation was located. Over the years, it's changed. We now allow multiple producers under entirely different ownership on the same tax lot. And the proposal here is considering removing that prohibition altogether and allowing common ownership between producers located on the same tax lot.
I want to say a big thank you for that. Something we've been asking for 10 years, and the ability to share resources, and be efficient is pretty remarkable.
Yeah.
Agreed.
I would agree too. That's, helps, being a small farmer, that helps a lot. And I mean, all the way up to everyone, that's really appreciated.
I would say this proposal is widely appreciated and widely supported. Thank you. Question?
Yeah.
Are there any changes to facility requirements around if you know, for a licensee who has multiple licenses on the same tax lot? So like a producer, do they have to maintain separate security systems? So they have to do separate drying rooms, or would they be able to share and consolidate resources like a vertically integrated license is able to do?
Yeah, I mean, at this point, there are no changes in the premises security requirements, so some of that, meeting the security requirements where they have the surveillance room located on each premises. I think those would still apply. In terms of drying rooms, there's separate rule language here that allows transfers between, from producer to producer, that would alleviate some of that, but this is just allowing multiple producers under common ownership, not changing the premises requirements of having those be separate operations.
Great. I'm not always an expert on every topic. Wendy or Alex, I don't know if I described that right, what vertically integrated licensees are able to do or not. In relation to some of this, and
Oh, I would
somebody could be articulated better than I.
I would just say, Alex Berger, I would just say that I recall having clients who had different licenses under common ownership in a single facility being allowed to share security systems and surveillance camera systems. So to the extent that those rules are open here, and it looks like some of the security requirements and license premises restrictions and requirements are open, perhaps a list of, security waivers that won't be unreasonably withheld for, producers on a commonly owned on the same tax lot would be really helpful.
Can elaborate on that a little bit, in that, currently, for example, producer wholesaler, common ownership, same premises, they can share the same surveillance system. Would that same allowance be afforded if I have multiple producer licenses all in the same facility?
I will check with our compliance folks, but I think that works because they share the same premises. Where two separate producer licenses are not able to share the same physical premises. They do have to be distinct premises. But I've made a note of things there.
Can I just say, obviously, we are a financially stressed industry right now. Any savings you guys can help us achieve would be greatly appreciated. And while, you can make arguments both ways, the more security systems you have, the more opportunity there are for breakdowns. That amount of work becomes exponentially challenging. And so there might actually even be I'd argue there's a compliance benefit to it as well. And, electrical wires can cross fences very easily. So as much as possible, I think we would all strongly support that similar type of framing and sharing of resources for this paradigm, as is similar to what Wendy just described.
Josh online, do you have a question? You've had your hand up.
Yeah, I just want to say I like this. I'm in favor of this rule. With the industry and where we're at, it's going to make expanding for the businesses much easier than having to buy separate properties or jump through hoops to expand.
I agree completely.
Given that this is open, it would be appreciated if the opportunity to expand on some of those existing compliance requirements for multiple licenses on the same premises could be revisited with changes.
We'll made a note Take over.
I have a question. If I have a comment on a rule that's not stricken or added, is that something I can bring up now or later under the same section?
Sure, if it's under the section, let's hit it.
Okay, it is page 10, and it talks about, checking, checking that individual is over 21. That's in the middle, so A, B, C, E, under E, second point. It just in terms of like checking that the person is over 21, I'm wondering, like, how do we make sure that happens? Also, is there a place, like, how would someone reading this rule know how to check that person is over 21?
So this rule is describing reasons that the commission can deny a license application.
Oh, okay, never mind.
And so this is, if a person does not have a good record of compliance, basically if they've had violations assessed, and that is one of the examples of a violation that the commission would consider in evaluating an application. Our next changes are on page 14 and 15. OER 845025, 1135, application processing deadline. And so it starts on page 14, continues on through page 15. As part of the licensing streamlining efforts, about 5 years ago, we instituted timelines for applications to be completed. That included having a 60-day period, working with an investigator. And if the application was not completed, then that application would be placed back on hold and then later reassigned to another investigator for another 60 days. This change is proposing to eliminate that hold and reassign step, just giving an application 60 days to be completed, and if it's not completed within that 60 days, then they can submit a new application, but that application will be incomplete if it's not completed within 60 days. Basically, at this point, we think it's reasonable to treat all new applications as being intended to be completed. At the time that these were adopted, there were a number of factors in some of the older applications that were still around. That this would be expected to improve processing times and simplify management of the application.
Alex Berger, I just want to capitalize on something that you said, Stephen, which was all new applications. So I would advocate for putting a start date here. I would say application submitted after January 1st, 2026. So that everybody has the expectation of the previous back into the queue allowance.
And somebody who answers less the question. Yes, please. Do what he said.
Yeah.
Any other feedback on this proposed change?
Really quickly under C, the otherwise has a basis to delay processing. I just want to make sure that if an application is ultimately considered incomplete, that an appeal can be made that there was a basis to delay processing. So I guess that would be in a request for reconsideration.
Yeah.
That would apply.
Yes, yeah.
You can argue that there was a basis to delay processing.
And just to be clear, that is delaying processing pursuant to 475C-049, which spells out some reasons why the commission can delay, or maybe commission can't delay. It gives us some guidelines on how to process applications.
Okay. Maybe spell those out. I mean, So there is a fixed universe of reasons that OLCC can delay processing.
I don't have the statute pulled up, but that's my recollection.
Okay, then I would advocate to eliminate that because there are cases where investigators are out of town for, right around that 60-day deadline. Or licensees are, or, I would want to expand a basis to delay processing that isn't necessarily preconceived. Because there may be many reasonable bases to delay processing.
Agree with that request.
As do I.
Just to clarify, adapting the option to go back into the queue, that means at the point of incompletion, they then forfeit their $250 application fee, would need to reapply and repay the fee. Correct.
Josh, go ahead.
Will the investigator have the ability to push the 60-day timeline like that is currently if they're on vacation or something happens where they can't be timely?
Right, yes, that's what's described in 2C there, where if there is a basis to delay processing, then the application is not subject to those deadlines and the investigator will communicate.
Well, that's assuming that that's listed in ORS 475C.0492, right?
Right, which I'll have to, I've made a note to revisit exactly what 475C.094 requires of OLCC to make sure that we're as clear as possible on that.
Question, is there anything within that timeline that states that the OLCC can push that timeline prior to 60 days? Or are all applicants given that 60 days to be ready equally across the board?
I feel like, could the commission specify this application only gets 22 days? Is that, under this language, I do not think so. Everybody gets that.
Okay, so that's 60 days allowance on both sides for the commission as well as the applicant.
But although, I mean, if the investigator determines that a denial basis applies and completes it,
Sure,
that way, that would happen. I'm sure.
sure, but not like forced readiness. You're either ready now or you're not.
Right.
Okay.
By the way, just really quickly, investigator on vacation is not listed under ORS 475C.0492. There's only like 3, and some of them are, related to OLCC has issued a proposed revocation, or the applicant applying is trying to buy an existing business. So I would advocate for removing that and including reasonable basis or listing things out.
All right. All right, next proposed change is on page 16. This one is related to camp and how applicants communicate with OLCC. This is just a pretty technical clarification. Basically, now that we have the camp system for submitting an application, submitting information to the commission, this clarifies that that is the primary way for information to be submitted, while still leaving room for if somebody from the commission, if an investigator or inspector requests information to be submitted in another way, then obviously it's fine to submit it in whatever way was requested.
I do find the fact that this is 0.1 in the section titled Communication with Commission concerning, given that it scratches mail, in-person delivery, fax, and email. So this is to expect that camp is the primary and only means of on-record communication between licensees and the commission.
Yes, so what this is talking about is if somebody's notifying the commission of the things that they're required to notify, an arrest or conviction, or a change in contact information, of a proposed alteration premises, any of those, that type of information should be submitted through CAMP.
Sure, could I ask that the language is adjusted to specify that this is specific to things that are open for amendment submission within CAMP? As it's written, it says submit anything in writing,
So
and
that's,
that's what.
yeah, so what sort of other, things do you have in mind?
I mean, there are certain forms that are often required that do not currently have the option to be submitted through an amendment in CAMP. There is no like option for open communication to the commission through CAMP. I can't just, hey, I have to tell you this. And so if communication with the commission in rule says if I want to submit anything in writing, it has to be through CAMP, that feels like if I don't submit it through CAMP, it's not officially on record with the commission, and that could be problematic.
I see.
I also agree with that comment.
Josh, go ahead.
What happens if camp's down and a notification needs to be done timely? What are you gonna go to email if that happens? Because it is down on occasion for maintenance and other issues.
That is a good note. Also, I will,
And that is specified in point 2, regardless of the method used, notification by 5 p.m. If I'm given a deadline by an investigator or an inspector, camp's down that day, well, I can't meet my deadline, then what?
Also, like you mentioned, the theft notification or robbery, like, I guess I just say, sometimes all that somebody has the time or space to do by a deadline is send an email, send a text, call somebody. Especially for like, I just think that those things should be taken into consideration and accept, and like, the situation should be, flexible for, challenging situations. There's a wildfire, right? Whatever it is, people lose resources, access to the internet, all the rest of it, and they still may be subject to deadlines. So I just would support everything that Wendy just suggested and Josh suggested, but also, seems a little bit hard for when there are some unpredictable situations.
yeah,
Go ahead, Jason.
Yeah, Jason Lampman here. I just think that in this day and age, that email should always be an accepted way to communicate so that we both have a copy in case there's some kind of discrepancy or something, a way to have information if we have a hearing or something.
I would agree with that.
I just want to say, Alex,berg, I agree with everybody's points that email should always be available, and that should also apply to the rule on page 15, which is a little confusing, because it says the commission will communicate deadlines and changes in application status by email or through the online platform maintained by the commission. And so I think maybe there should be an and in there, and I think that actually going through the platform sends an email, or at least I'm hopeful that it sends an email.
yes.
So I'm not even sure if or through the online platform is required, like, isn't it still by email?
Sir in the back, could you introduce yourself, please?
Could you
It's James Crawford. I'm late arriving, apologize for that. I'm extraordinarily hard of hearing, I apologize for that too. I'm kind of the impetus for Senate Bill 907. And I wanted to make the comment that the purpose of Senate Bill 907 is not to put the marijuana industry out of business.
Sir,
It's
you're welcome to stay and listen, but this communication and chatting here is for Rules Advisory Committee meeting members only. So you're welcome to listen, but you can't submit comment today.
I can't speak.
Correct. This is for Rules Advisory Committee meeting members today, but you are welcome to listen in. Thank you. Go ahead, Stephen.
I have one more point on that. Can you clarify in terms of communication coming from the commission to licensees? What, via camp, what constitutes that being not responded to, deactivated, something along those lines? I'm thinking in terms of like communication going out regarding worker permits or sometimes like label submissions, things like that. If a piece of communication to a licensee is not responded to in a certain amount of time, it's considered deactivated after X amount of days, a year, what have you. Can you elaborate on when in the rule a communication is considered missed and what that means? If this is going to be the primary.
I'm not sure that I followed the question exactly. I think it can request for additional information on the label application is different than the request for additional information on this application.
Sure, but in terms of communication with the commission, if a piece of communication comes out from the commission to a licensee and that is missed for whatever reason, whether they didn't get the notification email that something happened in camp and they don't check that and respond to that accordingly, at what point in time does that become considered incomplete, not responded to, and what are the ramifications of that?
I mean, my understanding is that information validly transmitted from a commission inquiry to a licensee is, it just, that has been sent. It's not, I'm struggling with when sending something becomes incomplete. Like there are particular contexts where there are deadlines that have to be met. If there's not a response within the deadline prescribed within the rules, then that leads to additional steps. But I'm struggling to find a general principle.
Okay, so that's specific to the scenario of what the communication is based around and the other rules around that. There's not just like a general, if there was communication coming through camp and it's not responded to, that defaults to whatever the time period on the, whether it's an application of whatever sort.
Yeah, I would say, if you have specific examples that you could send, maybe that would help me get my head around, but I'm not.
Okay.
Not following.
Okay, let me flush that out further. I'll follow up. Thank you.
Next proposed change is on page 17. This one is clarifying violation categories, and I want to jump ahead to the last change on this page first. That is a typo. It is not meant to say category 2. That is meant to stay category 3, as most of these violations related to changing the licensed premises are. The change that is being proposed is that it will really just clarifying. We previously had language in section 4 saying that if a licensee makes a change to the premises after that change is denied by the commission, that provides a basis to suspend or revoke. We've just clarified that simply that is a category 1 violation. And also, if a licensee makes an unapproved change that would result in an initial or renewal being denied, that is also a category 1 violation, just because that is a basis for revocation.
I bring up 6D under this rule. I think that should be removed for a variety of reasons. I could understand that if it was about on the licensed premises, but someone might not even own the primary residency that's on the tax lot. It could be the owner of the property they're doing it from. How are they supposed to control what that owner does or doesn't do to their home if it's not the licensees? And like I said, yeah, it just that being including the whole tax lot and not just the licensed premises seems incredibly problematic to me.
Yes.
I just second that. I've never understood how this rule makes sense, because it, for the reason that Jesse explained, that an owner of a licensed business does not have control over what's going on elsewhere in the tax law. And it seems like it's questionable whether OLCC has any authority either. And so I don't know, even if it's just a category 3, makes no sense.
Any other comments on? Yeah.
Stephen Massey, CDC dispensary. In that, section 7B, it indicates makes a physical change, and I think it should probably refer back to those specific changes in section 6. Just going on the, ripping on the same
Right.
statement, it gets overly broad in 7B, where it should refer back to 6 in those specific instances.
Mhm.
And then if I can, also real quickly, any physical change, number 6C, any physical change that would require the installation of additional video surveillance cameras or a change in the security system. Where I'm at, we have added cameras just for additional and better surveillance rather than because of a change to the premise. And this section C almost sounds like you could be in trouble for putting more cameras in the same spot.
Okay.
And I don't know what kind of language would clear that up, or that if I'm just reading it wrong, but we had that discussion.
All right, and we'll take a closer look at that language too.
Josh, go ahead.
If this is going to become a category 1 violation, I think there needs to be more education for licensees about this process. It happens a lot where people change their premises and then ask for permission. And if it's going to be this strict of a rule, I think there needs to be some bulletins to everybody so they're really clear that you have to ask permission before doing anything, because that's something that's overseen a lot.
And just to be clear, in general, violations of this rule are category 3. It's just if the change is impermissible, that it, if it results in a basis to revoke the license or deny an insured rule. That's or if the change is requested and denied and then still made. Those are the circumstances that would be a category 1. So in general, category 3, just in those specific circumstances, category 1. The next change is on the next page, page 18. This is implementing SB 907, the first part here. So same language that we looked at earlier about needing to, if you're a producer or processor moving to a new location, that is treated like a new application for purposes of getting the consent from the property owner. And then the other small change further down on this page is just the technical update related to changing written notice to just notice for things that can be submitted through amendments.
Just say, Jason Langman here, just say again, if it's possible for a property owner that, if they have a business within a family or whatever, that it's okay to just kind of reiterating what I said, a representative of the owner or business. Yes.
And we'll take a look at that in the context of the.
Oh, yeah, statute. Yep. Thank you.
Page 19, this is just related to the change in schools again. Removing the language about pre-K and kindergarten programs. And then the other change at the bottom here is clarifying violation categories. Section 5 of this rule describes operating an unlicensed premises, which is already a category 1 violation in other places. This is just clarifying, yes, operating without a license is a category 1 violation. All other violations under this section remain category 2.
Just to clarify, this consists with the grandfather clause that if the license is approved in a location prior to a school moving into that 1,000-foot range, they would be allowed to stay there.
Yes, that language, yes, is still. Next change is next page 20. This one is implementing Senate Bill 907. So this is kind of what Jesse was talking about with giving as much latitude within the renewal process. And most of the substance of this change is actually a little further ahead on pages 22 and 22. So there's a big block of text inserted here. This is basically duplicating the language that we currently have for retailers to provide tax compliance certificates. We have some timeframes built in for a retailer who's renewing to be able to provide the tax compliance certificates. This gives those same kind of timelines to a producer or processor who is renewing and trying to get the notarized property owner consent.
Obviously, I still believe everything I said earlier regarding this, and thank you for as much flexibility as we can build in. And also providing as many opportunities as possible for people to meet this requirement throughout the process, especially like looking at what they normally would have to do and trying to build it into that. That all being said, one of the things I did want to flag in general for this and later on with the tax compliance stuff is a general request for you guys to find a way to never shut down a license that when it has product that it belongs to other people or could belong to other people on it, that you find some way of doing a temporary extension, temporary license for a wholesaler or the originating licenses to come and recover their product. There's lots of different opportunities and ways this could unfold. And, you know, for the tax compliance certificate is the simplest one to imagine. You guys, they don't meet the thing, they don't meet the deadline, they shut down. All of the product that's still on premise is generally still fine. Money, much of it might be in terms. And, you know, it shouldn't have to be destroyed. Those people should have the opportunity to go and recover it. And or do a final, like, okay, you got 30 days to clean out your inventory type of situation. You failed, we will not do any more extensions, but now you have 30 days type of system. Even though you're giving them lots of warnings and they have that 90 days, at the end of the day, though, people may think that they're going to make it and then not make it, right? And so they might not have called everybody and said, come and get your product because we're not going to make it. People have hopes. And so this is
well, and you never know, you never know with the Department of Revenue, right? Like, I mean, you could get it at the last minute or you could not get it at the last minute.
Yeah. And so I think it would be, you know, and I've fielded multiple calls. It doesn't happen all that often, but if someone has $300,000 of product in their store or $100,000 product in their store, that can really hinder some other people, especially if it's from a micro tier or a smaller processor. It could really be a hit. And so we have lots of small businesses here. The ability to recover product if they can't recover money, right, could be a significant benefit. I understand there's some complications, but you know, a special temporary license, you can limit its abilities. There's lots of different ways I think to thread this needle or peel this onion. But I just strongly believe that product should not be needlessly destroyed, especially if it's not actually the license, like strictly the licensee who's in possession of it.
Rhea, do you have a comment or question?
Hi there, Rhea Miller. As a farm that frequently extends terms, I am in strong support of Jesse's comment, and thank you so much to the commission for hearing our comments and concerns.
Thanks.
Jason Lampman. Yeah, being a very small producer, one shop closing down would be, could be like a quarter of our gross. And so I think that's a really good idea to be able to, especially what you said about maybe transferring it to a wholesaler, because we're in a position now where I'm constantly asked to go on to terms, and you can easily tie up an entire micro tier's income for a longer or longer, so I like that. Thank you.
And sorry, Jessica, one more time, just to be, the tax compliance certificates, the clearest examples, because that's when I've gotten the most calls. I think it should not just be limited to a retailer. Wholesalers are in possession of other people's product. Processors are, even farms can. So I just think it should be a private one, because you guys may shut down licenses for lots of different reasons.
That would take a statutory change, but I will tell you it's on my mind, about the authority of OLCC at the end, when the license is expired, ends, how we deal with product. Pretty much your point, so I've been discussing that internally and working through that in my head. But you made a point that you can always transfer that product. We just haven't had folks doing that before they come. That is an option, and we suggest that as an option for them to transport to a wholesaler. But obviously we can't make them do that as part of that process. But I just want the industry to understand this is something that I am researching, I am looking at, might not be in this rule package, but it is something about, OLCC has to have the authority after the license expires or to continue to be able to manage some of these things. So I'm thinking through that in my head and probably be working through that in the next few months.
Well, I understand that you guys don't have the statutory authority for yourselves to take possession of it, but I think you may have the statutory authority to extend a specific type of licensing to a licensee to act.
Well, they can transfer it.
But not after the 90 days.
Right. Once a license is canceled, we have no authority over that license or premises any longer.
Well, that's what I'm
Like you're
saying.
saying, if the licensee could have done it themselves, but they chose not to, so the LCC can't just grab it all up and transfer it to the wholesale.
What I'm saying is don't cancel the license or find some other special, create a new
Well, the whole idea is that that's a cancel license, Jesse. It's not like, okay, you're canceled this date. We'll give you 3 more months to send marijuana wherever you want. I think it's more of a global conversation of OLCC authority and when it ends and how we look at extending that for the purpose of making sure that the marijuana doesn't end in the black market, number one. Obviously, that's a big concern. And then looking about making sure that we have an ability to do something reasonable after the license is expired. That's really what it comes down to, the conversation.
Maria?
Rhea Miller, do you believe that there could be a notification that could be sent through Metric if a license was up for cancellation, where a notification goes out to product origins to notify them that their product is at a license that's up for cancellation, and we could potentially collect if it were terms?
Yeah, I want to curb this conversation and go back to the rules, but the one thing you have to remember that anything to do with taxes, and this is one of the main issues, we even internally have to sign agreements that we can't discuss that internally with other members. So that would obviously, if it was a tax issue, we wouldn't be able to allow that conversation. But I think it's something we can work off online. It's on my mind. It's more of what I was trying to say, because we've run into problems with it, just like you run into problems with it. So I'm thinking about it, but I want to get back to the rack stuff. I just want to let the industry know that, I'm willing to have conversations, and it's definitely something I think is problematic for us and you, because the product, I don't want to go into the black market. I also think there might be some opportunity for some of the concerns that were brought forward today. So I'll turn it back to Stephen.
I guess I would just ask, in the context of this rule on page 23, right, in sub C, and in similar situations until there's a change at the legislature, right, where OLCC may have some some power to do things with cannabis that are on premises that are now, unlicensed. The language here, right, it states under this rule within 90 calendar days of the expiration date listed on the current license certificate, the commission shall consider the renewal application to be incomplete and the license to be expired as of the expiration date listed on the current license certificate. My understanding is that under this current situation and situations with TCCs, right, is that the expired licensee is operating under a conditional letter of authority, right? And so if there is some, if there's just some, if there's some runway between that 90 calendar day date, right, and the actual consideration of incomplete and inactivation of a license, I think that is the issue, right? Is that you have until 90 days to provide this signed notarized statement or to provide a tax compliance certificate, right? Which is great. But on that 91st day, if you are operating and you are trying to meet these requirements, right? If on the 91st day, all of a sudden, boom, like the certificate of authority, and I think OLCC may have the power to do this with through restricted licenses, and I think also has the power to, include specifics in that temporary authority to operate, that it's possible that, and it would be to the benefit, I think, of OLCC and the licensee, if that product could be lawfully transferred out in that sweet spot in between the 90 days of the actual inactivation.
Any further feedback on that?
I agree with those requests. I know that obviously the TCC is the best example that we have at this time. Yes, there are notices that go out surrounding the 90 days, and of course, not trying to skirt the regard to licensees for their responsibility by any means, because I know there's ample communication, but with what Jesse mentioned in regard to just, having hope that these things will get done by that time, I know that those issuances of notification of the license come very quickly, like 24 hours or less notice of your doors are walking tomorrow, you're done. Be mindful that that's like people's money a lot of time, and that's huge on this industry. And so keeping that in mind for the people who need that is helpful. I appreciate it. And thank you for, trying to suss out some way to make this work for everybody.
Thank you.
All right. Next changes, page 24. These are both ones that we've already discussed. One is the producers under common ownership on the same tax lot, and the other one is removing the kindergarten pre-K language related to SB 162. Any comments on those? Next changes after that are page 28 and 29. So there's some minor technical language changes here that harmonize this with the equivalent rule in our alcohol regulations. Also clarifies that both email address and mailing address are important for contact information. But then the real substantial change is extending the time frame where a personal representative is allowed to operate a business after the death of the licensee prior to receiving a certificate of authority from OLCC. This is proposing to extend that from a 10-day period to a 30-day period that they have to provide the documentation and get that certificate. And the other piece in here is on the next page, page 29, also allowing OLCC at its discretion to issue a certificate of authority that's valid for more than 60 days. So rather than having to revisit every 60 days, if what the circumstances are and that it will need 3 months, 4 months, that's within the commission's discretion with this rule change.
Thank you.
All right. Next up is page 30. This one was clarifying violation categories So this is just moving violations of C, which is sale of a marijuana item to a visibly intoxicated person, from category 2 down to category 3, and that's to keep it consistent with OAR 845-025-8520, section 10, which is essentially the same circumstances, and that one is already a category 2. This is just one change from category 2 to 3. And then the next change, so big changes to trade samples that starts at the very bottom of page 30 and continues through page 34. So there's a lot of changes in here. The ones on page 31, I can kind of summarize. So yeah, the markup here makes it very difficult to read, but basically section 4 of Senate Bill 558 sets the amount of trade samples that can be provided to each worker permit holder. And so that's 1 gram of flour per harvest lot, per strain, per month. 1 gram of cannabinoid concentrates or extracts per process lot, and 1 unit of packaged cannabinoid product per production batch. So that's all the basically implementing the limits per employee that are set in the SB 558.
So just, go ahead.
I'll say up at the beginning of this giant block of red, where it's basically protecting everything except for a marijuana producer, marijuana processor, marijuana wholesaler, or marijuana retailer. Does that indicate that a retailer can now provide trade samples to their own staff at any point from their purchased inventory within those limits?
That's a good question. The kind of the framework that SB 558 seemed to lay out was making trade samples more specific to the worker permit holder as opposed to the license. So each license type can provide trade samples to their employees up to the amounts described there. And then licensees who manufacture products can transfer trade samples to other license types. I think that's a good question. I'll need to look into whether non-trade sample inventory can be turned into trade samples by the retailer. It's designated that way by the original.
That's how I read that.
It was originally.
Yeah.
Yeah, that's how I read that. So thank you.
Go ahead.
Stephanie Massey, CDC dispensary. My question was in regards to the this is probably just something in process that maybe I just don't know, but how is the producer, for example, how are they aware of how many work permits are at a given dispensary in our case? Are they able to see those?
I don't believe they're able to see this, and they'd have to contact the licensee. Use contact on the holders you would want to get samples for. So and Jared, see what's next.
I just want to go back to what Marie's point. I agree with how it's going to be, with her interpretation, how it's currently written. I think that's how it should be. Right now I get calls from retailers quite regularly being like, can I do a special staff discount for 0.1 cents per, a cent a gram so that I can make sure they get samples, which I think is legal, right? So yeah, like employees can get all the samples they want as long as they buy them for 1 cent. But like, if it's free, all of a sudden it's problematic. So I think it would make sense for retailers, especially because some retailers have their employees make pre-rolls, on the downtime. And so that's actually an example of where internally they may actually need to do a quality control sample. And so I think that retailers should be able to make these samples, and that would be appropriate. And then the other comment I want to make is on page, or was it? On page 32, under, I can't follow the numbers, but it's the very first line on what I believe is page 32. The language does not include, right, is like, it's a 1 gram of usable marijuana or usable hemp per harvest lot, per strain per month. Is that the right line?
Yes.
Okay, yeah, that is the right language. For some reason, I thought I missed the per strain part. So. That's my mistake.
Jason, did you have?
Yeah, I wanted to, so I just wanted to be clear that I can, because I was having the problems giving samples of an entire pre-roll pack too, because it was already over the 1 gram limit. This clears that up, right? To
It does not change the package limits for marijuana items. And so if a pre-roll pack is not, if it has more than is allowed to be sold at retail, it wouldn't qualify as a trade sample either. But I mean, if each of the different pre-rolls are different harvest lot and strain, then those could all be.
yeah, so I was trying to think if that to be clear that it should be that just as a concentrate would be per packaged unit, that pre-roll packs should be, since they're below the per person item limit or per person limit, that I can still give out pre-roll packs, because I've never given out a pre-roll pack as a sample because it was 1 gram per person.
Oh, okay. I see what you're saying. Yes.
Just that it's because it is usable flour, but I don't want to be clear, if it's not in there, I'm not sure if it is, that I can give out a pre-roll pack per employee.
As each is.
That would be in that like packaged goods under that.
So just I want to make sure I'm understanding. Maybe we could follow up offline after too, but we're talking about like a pack of plain pre-rolls that just has multiple different strains or harvest slots in there. Is that
Even if it's one, I didn't see the distinction, because it's defined as usable marijuana, which would be 1 gram per employee.
right?
But once I wanted to be clear here, once it's packaged into a pre-roll pack, it's no longer usable marijuana, it's
So plain pre-rolls are usable marijuana.
okay.
So if it's all one strain, in same harvest lot, then that 1 gram limit per employee would apply.
Okay, so a 3.5 gram pre-roll pack is not 1 unit to transfer to.
Right, it talks about units in the context of cannabinoid products, but for usable, the statutory language from SB 558 is 1 gram of usable per harvest lot per strain.
Okay, I would say if it's possible that be able to give a pre-roll pack to as a sample, just like a customer would buy one, you know?
Right, yeah, I get what you're saying, but yeah, unfortunately, plain pre-rolls are usable marijuana.
I would want to echo that, and maybe there's a way for us to figure out how to put packaged products into either the cannabinoid category or another category. In order for us to sample a pre-roll, we have to create an entirely different workflow in order to sample something that's already in our pre-roll pack workflow.
Yeah, I've never given a pre-roll sample because of
Stephen Massey, CDC dispensary. I can tell you that based on the previous rules with the 5 grams, we would occasionally receive a pack. And because it was on the business versus all of the specific, we would each take one. And this method doesn't even allow for that now. And so, as both of them mentioned, now it's, we have to make a sample of a single, would make their whole production line is, this is per pack, and that's all we make. Anybody not engaged in the single pre-roll production process, they wouldn't be able to samples.
Joseph.
Yeah. Yeah, and I would say that in general, these rules or this statute is written to be a minimum, not the maximum. And considering that my understanding is correct, if it was an infused pre-roll, you could give out packages. So limiting it to just that the only thing that's kind of left out in the cold is marijuana only pre-rolls is a little bit like disappointing. And so I agree with everything else that they say, because again, they could also just create a 1 cent discount and then we're right back to essentially like accomplishing this, but just through an onerous, complicated process, right, internally. It's just, I agree with what everybody's saying. And that people should be able to give, the pre-roll should be able to be treated as packages. And however you can get there, I support, and our intention was to enable that type of activity.
We're seeing a much higher frequency of pre-roll products that are at or above the 1 gram size.
And just to kind of piggyback off that, and maybe it's getting into the weeds here, but holding regard to the manufacturers who, this is what they make, they don't make single units of this thing, that's problematic. And also that this concept essentially eliminates the in-house quality control. You know, what if an aspect that they're looking to test is, you know, how well does this pack of 5 hold up over time from the time that you consume the first one to the 5th one? Does it stay fresh? Does it last when you put the container in your bag and carry it for a week or whatever? You know, there's so many nuances to this that people want to consider when they're thinking about all aspects of manufacturing. And it seems that this is just prohibitive to the process of putting out a good.
All right. We've made a note on that.
So inches versus weight, if we can, on those.
If could it possibly, Jason Lampman, could it be tied to, because they have to be registered, right, with a label company?
So the labeling requirements are somewhat different for trade samples than in general. And so we essentially kept the
Oh, yeah, so.
the labeling requirements that currently apply to trade samples. The one exception that we wrote in is related to the quality control samples. Because of the way that this statute was written, more or less eliminates that distinction between a trade sample and a quality control sample. But we still kept a carve out where the licensee, producer, or processor can provide trade samples to their employees that without meeting the labeling requirements as they were able to under the quality control sample language. And the one other change in here, implementing a different section of SB 558, section 3. This would allow producers to provide samples of immature plants and seeds to worker permit holders who perform work on their behalf. And the proposed limits here are 4 immature marijuana plants per month and 10 seeds per month for worker permit holders.
Oh, I want to take a step back, just, sorry, I got lots of notes and I missed something. I want to make sure that stores could accept the samples for all their employees. Or for all stores under common ownership. So like Nectar could accept samples representing all of their stores.
Oh.
For them to distribute.
Yeah, it's gonna bring that point up as well. It's oftentimes that when you have chain retail establishment, one store or one location brings in the bulk inventory and then self-distributes amongst their locations. Sure. And that one store does the allotted amount of samples able to be received correlate with the employees in that license's CTS account, or can it be expanded to all of the CTS accounts?
That is a great question.
Because the warehouse staff is tiny and the retail staff is massive, 500 people.
Yeah, that's a great question. I can dive in and see what we can do there. Jason, do you have feedback on that?
Yeah, Jason Lampman, I just wanted to say that this is a great addition. This helps. The industry's moving so fast with strains and genetics and everything. This will help a small farm like me and also other micro tiers be able to, this just really helps a lot. So thank you. Great addition.
Any other feedback on trade samples before we move on to trade shows?
Yeah, one final note under 5. let's see, what is this number? C. I think several of the A, B, C, D things are actually in violation of the statute language, which says the OLCC may pass rules to regulate this, but they may not be more strict than requirements for sale to a consumer. Specifically requiring the name of the employee and the worker permit number is what I'm referring to. I'm constantly told that that is a huge burden, and just it's a nightmare. And half the reason people do the 1 for 1 type of thing is so they don't have to do this work. So I would like all of them removed, but if I'm being honest, I hate sometimes about myself. I think A and B could meet the criteria of what you sell, like for sale to a consumer, which is the weight and time of the sale, right? But I don't think C and D would meet the statutory, would be in line with the statutory language.
To add on that concept, I know this is something that comes up fairly regularly in your CTS data audits. And so, arbitrary information like this could free up time and resources for your staff as well, because it definitely is cumbersome for the industry folks to input that information, and it seems pretty senseless.
It's faster to create a SKU in your point of sale than it is to distribute 10 samples to your retail staff.
It's a challenge.
I'll circle back with our CTS team and our compliance folks and take a look at that.
I agree with that as well.
Next section, some major changes coming to the rules, marijuana promotional events. These are trade shows. Previously, a trade show licensees could only exhibit marijuana items. SB 558 Section 2 makes some major changes in license privileges where licensees are able to buy and sell marijuana items at a trade show. So this concept, this rule is basically keeping all the existing framework for a promotional event, trade show, in terms of how it gets approved, needing a control plan, all of those sorts of things, making sure that there's an organizing licensee who is responsible for maintaining the paperwork and verifying who all is participating. But for all the participating licensees, they can transfer trade samples, they can transfer marijuana items to other licensees in accordance with the licensees transfer privileges. So to implement this, the process right now for the trade show is that marijuana is brought there via a circular manifest. Manifest with the originating license as the destination. Those transfers have certain restrictions on how much marijuana can be brought on a circular manifest. And so that's what Section 8 here on page 36 is essentially doing, is taking those transfer limits for a circular manifest and having those apply to how much product can be brought to a trade show to be bought. Jesse.
Charlie Bowman, UCIO. So my first comment is on Section 6, little b, big A. Just another example of reiterating why recording the employee permit handle number and name would be really challenging at a trade show to do that. And so I think if that's a play, that's another reason why it'd be very helpful to correct that. Then then the next one is on 7 little a. Display any marijuana items or have items not in the participating licensee's inventory. It's a little bit broader than just this here, but display is not defined anywhere in the rules. And when I've asked about this before, I've been told this, what we just use the dictionary definition, I've come up with 3 different dictionary definitions. Some mention sort of like for promotional purposes, some don't. And it's explained to me, it's like displayed for promotional purposes. And this becomes very important in relation to other marijuana event stuff, because it could be a Cat 1 violation if you're at an event where marijuana's displayed and it's not a registered event. But there's no definition of displayed. So if it is for promotional purposes, I would strongly advocate for creating a definition of display that is that strict and explicit. And so as people know exactly what you guys are expectations are and how and when, something is legal, right? And it's not just like there's cannabis and yoga stuff, right? If that yoga instructor bought a bunch of product from a store and leaves it out, as part of that, is that an event that need to be registered with the OLCC? Maybe I'm being overly pedantic on this, but it's been something that's caused a lot of people a lot of anxiety and it's been very frustrating. And so just a general request that display be defined and limited to the greatest degree possible, so as to stay intent with the legislature's initial definition of like what a private event is and when these cannabis events are. Then my next comment, sorry, I'm just gonna go through it. And this is like, understand what you're trying to do with the circular manifests. In general, and we advocated for this during the legislative session in relation of Senate Bill 556. I don't think there should be weight limits or time limits on transportation. Especially when there's not the same weight limits or time limits on deliveries to processors or wholesalers. So it's like a farm can deliver 1,000 pounds without a top weight limit if it's going to a wholesaler. If it's going to a retailer, they have to wait 24 hours. And if they get one more order, they either have to do a second delivery or wait 5 minutes. So I'd strongly advocate for investigating and removing any weight limits or time limits on delivery in general. And just allow like everything is tracked and measured, like there's some other necessary reason, like let's talk about it, but I strongly advocate for reducing some of those requirements and providing much more flexibility. Delivery is one of the most expensive costs all of these businesses are subject to. When I was talking to people about the recall for, potency differential, everybody said it's not the relabeling, it's expensive. It's having to go and pick up from 100 different stores. That could be $10,000 or even more. So this is an example of where this reducing delivery costs is one of the places where we can find some money that's clearly being left on the table for licensees.
I'd like to reiterate that with, some examples. At Nimble, we're everywhere all the time. But we're only on the South Coast once a month. And we're only in Klamath Falls twice a month. And if I get an order for more than 25 pounds this afternoon, but my driver is hitting the road tomorrow morning, it could be weeks or a month before I have an opportunity to fulfill that sale. I don't want to wait that long. I'll lose that sale actually, because someone else will be on a different schedule and get there faster. And then to the 1,000, I think there's an example for every single one of them, right? We're jumping ahead, right? But here we are in this part of it. So I'm sorry, we're jumping ahead a little bit. It's quite easy for me to get 1,000 units of sale into a van and onto an invoice for the customer. That's only 100 cases. And some of those shops in the farther areas actually would like to keep a significant amount of stock because I'm only getting to them so frequently.
And then, thank you. And then just one final comment about this section. Is this where control plans are mentioned?
There,
Not in the edits, but in this just general open rule.
I mean, yes, this rule
Okay.
has a security plan.
Yeah,
requirement.
so with this, as someone who assists in some of these events, one of the most frustrating parts for people is the fact that they must have a set location within a room for where each licensee is containing their product. I can understand wanting a control plan for the room in general, but to have to require that X vendor does like all of the products at this exact booth at all time, it just really hinders the way that people can design and engage in these types of events. And because I have relationships with people who do this in multiple other states, there's no other state that they've been in that has that similar requirement. And so like in other states, vendors can move around the room and go to different retailers, but here all the vendors have to be safe. It's just, it creates a very defined way these have to be done. And I don't think that this is a necessary paradigm. I mean, it's a controlled event, it's registered with you. I don't see it as a huge security risk. And I think creating more flexibility there will be very helpful. It's not exactly in a rule, but it seems to be part of what the requirement of a control plan is. And so just, enabling people to say, like, you must be responsible for all product you have at site versus like, all your product must be exact location, at all times. I think, especially if we're giving away samples and other things like that, it will just get really hard to manage that paradigm. And if we're enabling transfers, so then they make a sale and they do transfer, now is that have to change? And the other thing is there's a licensee of record that is subject to extra risk for this. And so things like this put, the overarching licensee at risk for the behavior of somebody else. I just think it's unnecessary, and could help improve this type of commercial.
I'm the licensee of record on an event tomorrow. All of you should make that. Check it out. You've been visited.
Any other feedback on trade shows? This has been a good discussion.
Somebody who fields a lot of, am I doing this compliantly and what do I need to do in metric to make this okay? Questions? I second everything I said.
I agree too. I actually have not participated in these what you said about clarity, about the display and things like that. I just haven't been a part of it. I don't feel comfortable with exactly what I should be doing.
All right.
Can you explain what these trade shows are? Because I read trade show, state fair, or similar events. So, can you explain what all events are considered promotional events?
Yeah, I mean, it's the examples being the state fair and trade shows. Obviously, those are kind of different circumstances. I think the original language was mostly focused on, was just focused on displaying marijuana items as a promotional thing. So at the state fair, we can have the competition for who grew the biggest squash or something. And so you can do the same thing with cannabis plants and bring cannabis plants there and have a competition that way. This is expanding, SB 558 really seems to be expanding it to focus more on trade shows where licenses can all come together and show what they have to offer. Retailers can make purchasing decisions, when looking at those, and this allows actual sales to take place as opposed to just licensees meeting up as future sales.
We have quite a bit more to get through, so I think we need to keep moving and we can circle back to this. So, yeah, thanks.
And one final point, and just we can circle, just in case we don't circle back, is I understand where the circular manifest is a very handy tool for this situation, but my understanding is that retailers can pick up, every licensee can essentially pick up product from another licensee and drive it back to themselves. And so I don't see why a retailer shouldn't be able to take possession at the location and drive it back. But
Yes, that is, I think what this allows, it just has to reference the original circular.
oh, perfect. Great, thank you.
All right, next change is just deleting the quality control samples rule because the relevant parts of that have been consumed into trade samples. Next change is on page 41. OER 845-025-1450. This one's just clarifying that notifications of, that camera stopping is submitted to through camera. I think it's a pretty minor change. The next one, page 42, is a much larger change. So this is proposing to allow motion detection camera systems. Under certain circumstances, they still need to store all the video that's recorded while motion is detected, including all times when there are people present in the areas where camera coverage is required. And the system needs to be fully auditable in terms of being able to review the motion detection logs and any time the detection settings are changed.
We're thrilled.
Yeah,
Yes.
everybody should respect.
Thank you. My goodness.
Thank you.
I just bought a new camera system. It's like, man, I could have waited another. 6 months.
It might actually have this already built in.
Oh, that'd be something.
Yeah, it might just be a toggle statement.
Yeah, I mean, I'm sure you guys don't want to sit through watching nothing for days. Have you looked through this? Oh my God. It's so bad.
All right. Next proposed change here is producer to producer transfers. The previous language inline, it only allowed a producer to transfer to another producer if they were under common ownership. SB 558 made some changes, and so this is basically just removing the common ownership requirement. So a producer can transfer marijuana to another producer.
I would comment on that. It's based on that. That is excellent change. Thank you. And anything that we can do for to become closer to farming, being farmers being able to farm is so helpful. I wonder now if we can, for example, we sell hazelnuts on our farm. And so when we run out, we find an organic producer that's local in Yavapai County, and we make our products with that. We don't have to label 3 farms on there and the different addresses and things like that. It would be, our label is, that big. I know that there's different stuff for cannabis, but if we're able to, this is going to help us to operate like a farmers. And if we can, and it's going to help get through the oversupply that we always hear about. But if we're having to label a lot of things, unless it's absolutely necessary, it will help for branding, the least amount of, if we have to have a whole nother panel and everything like that, to be able to brand using some of the oversupply, if that makes sense. I don't know if any labeling effects of that, or if it's just gonna make it overly.
I'm not sure. I don't think we have anything related to that proposed in the labeling rules.
Okay. Like I said, I'll send an email or something afterwards.
What he's asking is similar to, if I have a vineyard and I run out of grapes, I can buy the neighboring vineyard's grapes to continue to produce my vineyard's wine.
Right.
It would be nice if that could be true for cannabis as well. Like, okay, I ran out, lucky me. You have an oversupply, let me buy that and put it in my branded pre-rolls without having to extend.
And buy all new packaging.
Right. The only thing that would change would be the license number and the harvest date.
Okay.
From the other producer, which is variable data, so labeling shouldn't really make a big change in that aspect.
Ria?
Ria Miller here. Wendy and Jason are bringing up some excellent points. Thank you so much. And I just wanted to thank the commission for this rule change. It's going to be a great change for producers. Thank you very much.
Huge, yeah.
Thanks, Ria. And then the other change on page 44 is just related to trade samples. The language about quality control samples has just been changed to trade samples. So the next set of changes are pages 46 through 48.
Wait.
Oh, yeah, go ahead.
So I want to go back to 2800D. And you removed under common ownership. Here, and I think you removed common ownership for retailers and other places as well.
Yes.
And we're trying to figure out if that was intentional and what the input, like, what would it, if your change is going to affect, what would that mean for retailers?
So yes, that's the next proposed change here. So right now, retailers can only transfer to other retailers that are under common ownership. The definition of common ownership is not straightforward because it includes financial interests. It's minority owners that don't rise to the level that they get disclosed to OLCC. So yes, we are proposing to delete that under common ownership language and just allow a retailer to transfer marijuana items to another retailer, regardless of whether they're under common ownership or not.
So they essentially have the privileges of a wholesaler?
Right, yes.
It's similar to removing the kind of like the producer transfers.
Correct.
Because that removed common ownership between producer and producers. So it seems similar to do it with retail as well, because that common ownership was removed from statute.
So I would say, like, generally speaking, I'm always a fan of as much flexibility as possible for licensees. This one does give me some consternation because I think there's a structural difference between a producer selling product to a producer versus a retailer sending product to another retailer, which is like when someone sells product to a producer, they have an expectation of what's going to happen with that product, which is going to be sold to, like, that producer is going to do X with it. But when someone sells it to a retailer, their only expectation is they sell it to a consumer. And so, like, they could be losing control of their product in a way that they're not fully accounting for. And I imagine that there are lots of wholesalers that would find this very problematic.
So in regard to if a product recall comes into play as a processor or maker of any product, now I potentially no longer have any idea where all of that product lies in the state.
Steph, that's a CDC dispensary. I can say as a retailer, there's not a whole lot of reason for us to ever do something like this. If we were ever to say run out of something that we had maybe promoted or needed to provide to our consumers, we could go back to the producer, processor, wholesaler. We wouldn't be talking to a competitor retailer. I mean, I'm sure.
A retailer that's in a partnership, we have looked into branching off without the partnership that we currently have. And in order to transfer, if we did that, in order to transfer between the two dispensaries, if they didn't have the exact common ownership, we would then have to have a wholesale license to transfer between the two of us. So that's where it would become beneficial. And due to competition, as a retailer, my local dispensaries aren't gonna be buying from me. So they would, if I wanted to engage in wholesale activities, I would have to really create a new business to properly sell out in this competitive industry. So retailers want to go and give me money as a fellow retailer. So I don't think that it's as big of an issue. And there are probably a lot of dispensary owners that don't want to maybe go and create a dispensary with their same partnership people, but they want to be able to switch it between the two.
Just my understanding, for just one point of clarification, is we did get rid of the exact ownership part a little while ago. So now you just need like a very small financial interest can accomplish that. So just FYI, know that the first thing has already been addressed because we ran into that problem with that exact ownership paradigm.
Yeah, then in that case, you're kind of stepping on wholesalers' toes, because why have a wholesaler license it there's no need for one.
Yeah, I would just add, it does seem like a solution seeking problem.
David Stanford, OLCC. The wholesaler would still have two unique privileges, which is that it could arrange testing on behalf of another license and transport between other or two different licensees as an in-between, so it wouldn't completely erase. Just a kind of pedantic point I'll throw out there.
Okay.
Two things we don't do.
I forgot something that I wanted to say on the deletion of the quality control samples.
Yeah.
I am a farmer, I'm a producer, and we had the ability to have 28 grams as a QC sample, which an ounce of cannabis really just shows you in the jar what it's gonna be. And in a community, like Wendy had mentioned, shows you over time. I eat as many apples when they're ready, hazelnuts, veggies, everything, and I know cannabis is different, but I use cannabis. And then under this rule being a micro tier, harvesting 2 strains per month, I can smoke 2 grams of my own cannabis only as an owner. That's just, I don't think that's fair or reasonable for a business owner. If you could even just say, owner operator can still have a 28 gram quality control samples. I want to be able to tell people about my product, and in the moment and over time, I don't think, I think that's just a little over restrictive.
Rhea Miller, I share in your sentiment as a producer. I find the gram per strain per harvest batch a bit restrictive with seeing quality control samples out. On one hand, to a certain degree, like I found 5 grams for trade samples somewhat restrictive, honestly. But perhaps it would be nice to see something more along the lines of like a maximum of the legal limit, like 28 grams per employee per month, and not be so specific to the strain or harvest batch. Because we try to harvest in large batches, like 1 harvest lot per strain, so that all of it is continuous and can be easily combined without doing the multiple harvest batch for metric simplicity. So yeah, I would appreciate seeing a little bit more constructive thought going into these limits. Thank you.
Thanks.
I would agree with that. Is there any reason that sampling limits don't or can't match purchase limits?
I'd have to take a look. I don't have the bill in front of me, but it's on my list of things to check into once we're up here.
That's a good point. Like, why isn't it just a second limit?
Yeah, I would have to completely agree with the limited and the restricted limits that you guys have going on this. It's really hard to regulate from a retailer perspective. We're already regulating everything, and then this is trade samples. Now I can get in trouble by saying checked off the second sample to the same employee. It's just really, we're already so heavily regulated, and this is sample products we're talking about. We're not making money. We're not doing anything. I'm having to pay my highest paid managers to even manage samples now at this point, and that's just making it more restricted.
Sure. And yeah, just to be clear, that language is more or less directly from SB 558, but I'll look at the flexibility that we have in to work with that.
I just, one final point, Jason, I don't want to have to buy my own product for the farmer.
All right, next couple of changes on pages 50 and 51 are just again implementing the language from SB 162 about the school proximity to retailers. Page 52 is changing quality control sample to trade sample under the processor, transfer privileges.
Hey, Stephen,
Yeah,
real quick question. Is there a break written into the agenda? It's been almost 2 hours and I could certainly use a break. I don't know.
We could definitely take one, or you can just take money.
We do have to be out of this room by 3, so, and we still have a lot to get through, so you can come and go as you please.
Since marathon.
Next major change is page 59, dealing with target potency. Anthony, do you wanna?
Yeah, Anthony Galtowski, OLCC for the record. So in 7,000, we have added a definition for target potency, which will become relevant a little later in 7030, but target potency is essentially a number that you're hoping to hit. For an edible, 100 milligrams is the easy one. So in 7030, we added into subsection 2 that a target potency must be within 10% of the actual lab calculated values, otherwise untruthful and misleading. This is not new. This has been in place since 2019 via a compliance bulletin. So we're just codifying this in the rule now, just to make it more clear for licensees what OLCC's expectations. Yes.
Does this apply to flour as well as processed goods or just?
Flour generally doesn't have a target potency. I'm not quite certain why somebody would do that. In my experience here, I've never seen somebody put a target potency for flour.
Well, let's say someone tests their product and it's 19%. Can they add 10% to their label to make it look
No,
like
this
it's
is
over
nothing to do about adding anything to test results. You still have to display your actual test lab calculated values on the label. So here's an easy example for an edible. So you have 100 milligrams of THC on the front of your edible. That's your target potency. That's not the actual lab calculated value. So on the back of your label, you'll have your test results for THC. Those results can be between 90 and 110 milligrams. And that is within that plus or minus 10% range of target potency. So that's compliant. But if you have, let's say 85 milligrams of THC, that's untruthful and misleading because your consumer is expecting to get 100 milligrams, but they're really not getting anything close to that. Does that make sense?
I might ask that you specify that in the definition of target potency for products that that's applicable to.
It would be, it would be applicable to any product. Essentially, if you are using a target potency, which is completely voluntary, it's not something OLCC requires. It's strictly for marketing purposes, right? So for any product. So sorry if I cut you off.
Okay, so if I'm a producer, what's stopping me from adding a target potency of 30% to the front of my label for the eye grab at the consumer, and then lo and behold, it's 21% in the fine print on the back, and it's up to them to suss that out. Is that compliant?
Math is not my strong suit, but
No, it wouldn't be compliant.
It's within 10%.
So 10% of the value.
Yeah.
It's not, so you have 3%
Okay.
total percentage points versus percent. And so, but even then, it would need to be an approved label, so you would have to be changing your approved label every single targeted batch. I mean, that'd be a extremely onerous task, but.
Agree, we just, the topic of conversation was that we don't want people to exploit this language.
right. And I, in my experience, I haven't seen this language be exploited. And just to be clear, you can't do this on a generic label. This has to get pre-approved by OLCC. And in the 8 years I've done this job, I've never seen anybody ask for a target potency on thought. That just happened. And I think for this,
But your point you're saying is you would recommend we change the rule to say you can't put a target potency on usable marijuana?
Just be specific in what that means. I think it's confusing. I know that when a decent group of us had this conversation, it was like, well, why is this coming up now? And your intention is what I interpreted off of this, but the conversation was like this, as it's written, could be exploited by somebody who just glances through this and wants to capitalize on an opportunity to make a grab at visual appeals to the consumer.
Yeah, I think, I'll take that into consideration. And then the other change to 7030 is just the addition of principal display panel requirements. If you are having a target potency, it has to be front of the label. And, that's just so a consumer doesn't look around the label, see 100 milligrams at the back, the side, and think, oh, okay, that's the actual lab calculated value. That's what I'm getting. So it's making that more clear. And then the other change to the labeling rules is 7120. We are removing the address requirement from other cannabinoid products. So
Thank you.
Yes.
that is infused pre-rolls, flavor vapes, and food products. So the other thing I'd add is if these rules are adopted January 1st, this would become non-required information. So any licensee with an approved label that has their address on it could remove it without going through OLCC's process. They can just exit out, whatever you want. And the other thing I'd point out too is I would refer licensees to the definition of place of address in 7,000, which does allow for the address to be a PO box or something like, a mailbox, et cetera, type of store, a place where you receive mail. It doesn't have to be the physical location. So that seems to be a constant source of confusion. Just
Thank you. This is something that the industry has asked for in relation to the robberies. I appreciate you guys taking us seriously on this and taking action on this. A lot of people are appreciative. Yeah, the 7,000 piece, I've had many conversations about those. People seem very confused by it. So really, thank you for pointing that out. Any bulletins you guys send out, maybe reiterate that, would be really appreciated. And I just want to confirm for the record that edible manufacturers are still subject to requiring this, not because of you guys, but because of OHA requirements around food.
Oregon Department of Ag.
Sorry, that's what I meant.
So anything you're ingesting, so edibles, tinctures, and capsules as well. So that's all required, and that's ODA statutory requirements. So yes, as you alluded to, are in the part. And that concludes the things.
Thank you. Last couple of sections here, 7,700 is the biggest one. This one is transportation and delivery of marijuana items. First change on page 67 is just a change related to the common ownership term. If all the other proposed changes are adopted, this would be the last section in the rules that uses the term common ownership, and it's not great practice to define the term and then use it only in one place. So this would change it to the same or substantially the same ownership, basically same intent, but without the need for a defined term.
What do you guys anticipate defining this as in application? What does the same or substantially the same mean? I don't know. I feel like I know less now.
That's fair, yeah. So I guess if we move forward with this, maybe we could clarify by borrowing more of the current language from the definition of common ownership. Because that's essentially the concept here is keep it the same, just without relying on that defined term.
So are you saying that with the changes proposed here, the definition of common ownership would just be removed because it's no longer mentioned?
So that section of rules is not open here, and that would have added a whole bunch of extra pages to this packet. But it would basically be laying the groundwork for being able to do that in the future if all of these other changes related to common are adopted. Okay. The next change here is on page 72, related to circular manifests and trade shows. Basically requiring that the manifest, when doing a circular manifest, if you spin off the secondary manifest from that, requiring that the original manifest number be referenced on the spun off manifest just for traceability purposes, so that it's clear that the new manifest came from that original circular manifest. And then clarifying for traveling to a promotional event, the limits in this rule are slightly different than the limits in the promotional event rule. So just making clear that when traveling to a promotional event, the limits proposed in the promotional event rule would apply to that circular manifest.
This is Marissa, can I make a comment on this one? This is, the manifest number of the original manifest is actually something that we already do for our own traceability and also put the invoice number everywhere. But I want to highlight that this is really something that that should be doing for you. You should be able to create a manifest from a manifest. There's a third party.
Any other feedback on these changes?
Is there a, Jason Linton here, is there a, I'm looking for, amount of time that you can be gone if you were to be across the state, to the east or south? With, I guess I would go for, under the rules for delivery, right?
Right, so we're
60
not,
hours, isn't it?
that sounds right. We're not proposing any change to that current time.
What is the rule open? That's a question. Obviously, you know, anybody who worked with me or talked to me about Senate Bill 556 would know that we are strongly in support of extending the time the product is able to be out on road for delivery to as much as possible. You know, anything more than 60 hours would be progress, but it would be nice if somebody could leave on Monday and come back on Friday. Especially if they're going to Eastern Oregon, having to do multiple stops. You know, Oregon is a big state. We're the 10th largest state in the country. And there's a lot of territory and there's a lot of dispensaries. So as much flexibility as could be possible, you know, it is something that I think could really benefit the industry. And I'd strongly ask you guys to look at what other ways can you make delivery more affordable and reduce costs and increase efficiency. And I think extending the timeline is a big one. And it's along with getting rid of the time limits we mentioned earlier.
I'd like to reiterate that with also another goal, but I'd like to visit Kindleaf and carry on to Ontario and then go to Joseph and then spend a day or two in Bend and then have a salesperson, you know, do a loop and work their way home and be efficient, being multiple trips back and forth across the state to stay within that.
Erin from Kindly, being over in Eastern Oregon, I get to see the struggles that people have working under these timelines. You're going to have more compliance if they have more time. They're rushed. Retailers need to have appointments. We need to have our person there available for them, but when they're just rush, which I get it, it really creates a lot of tension between the companies and it's hectic. So if they could have more time, it would be greatly appreciated from our side of the state in particular. We just need to have more patience and more time with the vendors. We get a lot of product. We have to check every label. We have to check every metric tag, and we can't do that if they're rushing to get on, like she said, to that big, huge loop. Or I feel really bad for the companies because they're sending a driver out and then they turn around and have to send a driver out again 2 days later when if they had more time, they could do a whole loop around the state.
I would say for Jason Linton here, from the micro tier perspective, most or a lot of us are owner operators. And if I could take 1 week every other month and go out and sell, it would be amazing. I've yet to sell in Eastern Oregon or Southern Oregon because to make it worth it, but our business is growing. It would be really helpful to be able to do what Marissa was saying, like a week, make the loop. It would be super helpful for our business.
Thanks.
Not to mention the environmental
Yeah.
improvements.
We're just saving you gas money.
And I think the other thing is, again, you guys aren't saying you can't make 5 deliveries to Pendleton or send 1,000 pounds. You're just saying you can only do it for 60 hours, right? But if you send one car one day and another car the next day, the volume's still the same, right? It's just how expensive and complicated is it to do that volume? And so I think that this is a place where there's reasonable expectation for, or consideration for expanding this quite significant, significant.
It sounds like another 48 hours would make all the difference.
All right. And that brings us to almost the last thing is, page 76, continuing on to page 77. So this one kind of goes along with the next change. So this is the rule about prohibited conduct. Basically, we're defining or specifying certain information that needs to be maintained in camp. We're doing that, or proposing that in Division 4, which we'll talk about in just a second. What the changes in 8520 do is just basically assign a category 4 violation for failure to maintain the information that's described in section 4, or in Division 4. And so then continuing to the proposed change to Division 4, this rule historically has only applied to alcohol licensees. It was last modified in 2002, long before adult use cannabis was legalized. So there's some changes here. The rule is basically about communication between OLCC and applicants, licensees, permit holders, etc. So this changes some of the definitions to make it so this rule applies equally to alcohol and marijuana businesses, just to make sure that we're keeping parity between them. And the real, when the main changes are just in terms of what needs to be maintained in camp. The contact information for any person with there's a licensee or applicant or a permit holder needs to be kept up to date in camp. And then for license holders specifically, that if you have to have a user account that is basically anybody with a user account associated with the legal entity that holds the license has authority to request changes for any of the licenses associated. So if a licensee wants a person to only have the authority to request changes for a specific license, there's that authorized representative section in camp where a person can be associated with a specific license. If they have user access account for the legal entity that holds the license, those people have control over the business. And typically, that should be at least one licensee, or if not a licensee, then a designated is exercising that control over a user account for that legal entity.
I did not understand these rules when I read them. I still don't completely after your explanation, because you refer to a license holder, but that is not a defined term. Did you mean licensee or certificate holder?
I mean, yeah, licensee is the main circumstance where that applies. Where
Here is a licensee of person, a natural person or an entity.
Can be out. It is.
But it is the name that is printed on a license certificate. Is that correct?
So that'd be the licensee. It's the name
Right.
printed on the licensee.
The licensee of record is not defined here.
So it is okay. So that leaves a cross-reference to where we really define that, or just actually we can have that. Because I believe that's defined the same between alcohol and marijuana licenses.
I guess it's hard to comment on this because I don't understand it very well, but I just want to make sure that no one can be issued a violation for how camp is currently set up. Is that accurate? Meaning, for example, I am an authorized, like my firm is an authorized representative for a number of different licensees, right?
Mhm.
But because authorized representatives can't do everything in camp necessarily, I'm also given their login information. I don't want that to become a violation like January 1, 2026.
Right, and that wouldn't be a violation. It basically, if they've given you user account access on the license, then that's effectively saying that you are a designee that's authorized to submit information for the whole legal entity, for all the licenses associated with it.
Okay.
So does that licensee designate differ really from what is currently happening under like the LRA amendment?
So the difference is the LRA is specific to particular licenses. It associates a person to one license or, I think, license will process multiple license ones when they apply it to several, but they're just associated with those license objects, where a user account is associated with the legal entity that holds all those licenses, and so has authority to submit things for all of the licenses, not just ones where they've been associated.
Well, yeah, but a user account can be associated with a number of different licensed entities.
Right.
Right, it's not attached to an entity that is licensing of record.
Would that be the difference between like Can Experts or Emerge using the LRA amendment as compared to like, hey, what's your access code? We're gonna associate to your license. Okay, so continue to use the LRA amendment and you'll be able to do what you need to do once the application is completed.
Right, or, I mean.
Oh, what I'm hearing is I should be doing what I'm doing in terms of having the login information.
Yeah, if that's what if that's what the business wants, they're designating you as having that authority, then yes, you can be associated with their legal entity and have the authority to do that. This is just making clear that the licensee is responsible for maintaining who has access, who is associated with that legal entity. So if you submit, if you submit a change that they don't want to make, or more realistically, a person who has a falling out with the business submits something and the legal entity, the licensee hasn't removed that person's access, the commission doesn't have a reason to consider that submission invalid. If the
Okay, so-
licensee gives them permission, then.
So this is sort of a CYA for the commission. Okay.
Right, this, yeah, exactly. This is making clear who we can receive and accept requests from, basically.
Okay, and so I guess I would just ask that there be robust education on this for sure. And, give the steps that a licensee of record needs in order to, remove somebody who is rogue, or, I mean, that's tough, right? Because if there's only one login for a licensee of record, right, that is owned 33% by all three.
But then, I mean, each person they probably should have their own user.
Well, right, but I mean, OLCC is still gonna look at that, right, as three licensees, all with the power to make changes.
Right.
So I think the saying is, so let's say one of those people goes rogue, how do the other two people lock that person up?
So within camp, it's my understanding that anybody with a user account associated with that legal entity can change who has access. They can go through the list of what other users are associated with that.
What is- Yeah,
That's gonna get real messy when we.
I'm great. I mean, it's already, right, like, this isn't a new.
This is the new message.
Just trying to fit them.
These new rules only sort of clarify definitions and who's responsible for what.
Right, yeah, basically, and require that people maintain up-to-date contact information. But yeah, mostly it's just making it really clear that if you give somebody user account access associated with your legal entity, that means they're a user account that's associated. They have
The designee.
Right.
Okay.
So is there anything to say in protection regarding if the road person is the first person to get into camp, like, screw you guys, you're deleted, this is mine now, and I'm gonna just withdraw the application, dissolve the license, you know, we're done. That is valid as far as the OLCC is concerned?
That's what that is how it is now, then you call me.
Running with all the, you know, this is a.
Your number for the log here.
Yeah, if you could just put my phone number. Everybody's making count that.
This doesn't solve any of this doesn't solve most of the messiness that currently exists. There are tricky situations. Those are all handled on a case-by-case basis. What this does is just make it really clear that when you as a licensee are giving somebody else access to your account, that they have that access and can do the things that that access entails. So we just want to make sure that's abundantly clear.
Is this at all motivated by like limitations in camp and setting up user permissions?
Not as far as I know.
No.
Well, during our discussions about the rules, I would say that people were very curious about if there is the opportunity for make user permissions more robust within camp. So that, not necessarily for the situation that is being discussed right now, but more about for like what information employee can even see, maybe, right? But they may not want an employee to see their address.
I have an employee, I have an example, I have an employee, I'd like to make her in charge of all of our packaging and pipeline. I can't give her access to camp without giving her access to our license information. I mean, there's sensitive business information that I don't necessarily want an employee to have access to.
The example that comes to my mind as well. So it's just, it would be
Yes.
nice, I think it'd be nice to have
Cheers.
somebody else on my team.
Yeah.
That I can't give them that access because it's like there's too much. So some sort of segmentation there would be really nice.
Technical.
And the people who are asking this and experience with it have a suggestion for the tiers, you know, if it's.
I can certainly, I'm not at this moment, but I can definitely give that feedback.
Yeah. I think this would be something that was very desirous, because
There's all sorts of, I can think all sorts of little examples, of this person, this thing, that person, that thing, as opposed to being like the sole funnel for all of it.
My understanding was that the like, different permissions-based capacity was supposed to be built into camp, but doesn't quite function like that yet.
I'm not familiar with it. I'll check in with our account folks. All right, and that brings us to the end of the proposed rules.
So we have some time for general questions, comments, concerns, but before we do that, does anybody have, with the meeting materials, I sent out a fiscal impact statement questionnaire as well as a public health and safety for some of our agency folks. Does anybody want to discuss the fiscal impacts or public health and safety concerns on record today?
I think this is possibly the first track that I've ever been to where it decreases the costs.
Yeah, I was gonna say the same thing. It's really helpful from the microtier perspective at least.
All right, well, we have that on record for you guys.
That
No,
So
so,
it's fair because you have it on record every time I've said this.
so if after this meeting, you think of anything, fiscally or otherwise that you would like to contribute, please feel free to email that to me. And also, some of you might know this, but for anyone who is new, per Governor Kotek's new rulemaking directive, any fiscal impact statement, public health and safety, or written comments that we receive will be posted on our website. So I will redact any personal information, and I think we're only required to put first name and last initial. So nothing personal will be attached, but that will be public. And barring any catastrophe, this package will be noticed on October 1st. So the public comment period will be for the month of October, and we will be holding a public hearing as well. So yes, I'll open it back up for general.
Is the public hearing date set?
It hasn't been set quite yet, but it'll be after the 15th of October. But we'll circulate that information to everyone.
I do want to go back to the definition of trade shows and the like. To me, the rule does not make it clear. I read it and I checked with a couple of colleagues, and it's not clear to me what those shows are, or like what all falls into that. And part of that thinking, one desire for clarity is we want to know if any of these events will include youth participants. So want to know, okay. So I'm
Well, I
saying
don't-
no, but
I mean, I don't know about like the county fair. Or something like that, the state fair, but our events are not able to do that.
yeah.
So like what a
So-
trade show is not able to do that because it's part of the control plan,
Mhm.
right?
Yeah, and
Yeah.
it explicitly, no minors, and the event that we're having tomorrow, you have to be pre-registered and a representative of a license in order to gain entry.
Yeah, because I read later in the rule, it says, the plan needs to include, an area, like how to keep youth out of that area. So it makes me wonder if there's gonna be other areas at the event where youth will be allowed. And maybe that is because that state fair is included. So, yeah, I'm curious, like what, how that will all work in the state fair or other kinds of fairs that, I think there's room for more clarity.
And I might be able to help a little bit with some background on that. So the state fair language got with the statute, and Jesse, you might remember better, I think it was 2016.
It was pretty early on.
And basically people who had been part of the medical marijuana program that were then going to be part of the new, what at that time was recreational program, wanted to be able to take their plants to the state fair. So they actually had that language was added to statute that year, so they could bring their plants to the fair that year because it was newly legalized. So it was actually before OLCC even had any licensees, and it was everybody that was still technically under the medical marijuana program. And I think that was the last time that there have been plants at the state fair.
I just heard from somebody.
Really?
Through the county fair, the state fair.
Or the county.
Yeah, I don't know. Yeah, but my understanding was the purpose was for like grow competitions.
To show
off the plant and do activities that other plants are able to do, like you have a pumpkin growing competition. You have a cannabis growing competition.
Yeah.
No consumption is allowed.
Yeah, and you're also allowed.
No sales are allowed.
You're allowed to have 4 plants per household. And so some person who's just an average person who had a growing plant wouldn't be licensed by the OLCC, but they could probably enter a contest at the state fair. So, but yeah, like Jess said, no consumption, no sales, nothing like that. It was just for people to be able to, kind of like Jason was talking about, show how they're regular farmers.
Yeah.
But
Then you can
not,
show off your prize pig.
but not having that geared towards minors or youth.
I mean, yeah, I'd like to jump in. I'm Jason Lemon. I won actually this year at the state fair best wine grapes, red wine. just, it'd be the same thing as I want to be able to show my plants there as well. It is farming, and that's what I was saying, helping this, the more we can be more about farmers, because I think we all agree that plants are safe, you know?
Yeah, and, but with the, like, there will be samples available, sample products as well?
With the new rules, that only applies to people that have licenses. So it's one business and another business coming together and giving each other samples or their employee samples. Somebody like me, who's not a licensee, couldn't come to one of these and get a sample. It's not for the general public at all.
Right.
Only business to business.
Which is currently legal, so it's just saying what you can do in your normal course of business, you can also do here.
The general public, even those over 21, can't just walk into this and say, hey, I like cannabis, can I try that?
Yeah. Yeah, it's just a little confusing about the state fair, like what will all be happening, because I think state fair is a little bit more inclusive of others, like, right? Not the retailers and business owners, but I understand how thank you for the background.
Anything else? Is there anyone, any of our RAC members joining us virtually that have any final thoughts?
I have one final thought.
Go ahead.
Thank you for the positive changes in here for small farmers especially. And I always ask at some point if micro tiers could be able to sell direct to customer. Thank you.
Kind of reiterating, obviously everybody is really happy or generally happy with these rule changes. And I'd say that obviously we brought up some new topics or new aspects of these. Please, if there's any way we can be helpful, if you are considering any of the additional concepts or comments we've made, do not hesitate to ask. I think all of us are invested in making sure that these rules are the best possible. And like, people are desperate for any financial relief possible right now. So if we can improve them, we will dedicate time and resources to make sure we give you all the feedback we need in a timely manner. You know, October 1st is not very far away, so we will do the work if it can help improve these rules.
Josh, go ahead.
When will these rules go into effect?
If they are approved by our commission, they will become effective first of the year.
Okay. Thank you.
Anything else? All right.
Sorry, final thing.
Yeah.
I will try and provide resource, like a definition of display, just FYI, and follow up with that. So it's clear what I'm asking for.
Sure. I have one more, just something I didn't see very much in the rules is any resources around checking for the age. Person is fine. So I looked and I didn't find too much about like how would someone check someone is over 21 besides a visual. Yeah.
Yeah, so our inspectors, do they still offer the ID check and training when retailers request? Yeah. So, yeah, it's, those resources aren't built into the rules. The rules are more what people can and can't do. But yeah, for marijuana ID gets checked prior to every sale. And we do have our minor decoy operations to check compliance with that. But yeah, for resources on proper ID checking, retailers can request that their local inspector.
All the employees also have server permits or license permits, so they've all taken an educational course to get a permit, just like a bartender at a bar.
And to test.
Or also like at Walmart, when you go buy cold medicine or something, your system stops you and it tells the worker they need to check ID. So does our point of sale system. So we're also required to check ID when they enter the retail establishment and at the point of sale. So it goes further than the alcohol side and the dispensary side. And these are just amendments to the rules. So there's going to be like an entire ORS saying that's.
Yeah, Jenny, if you're looking for what forms of identification are acceptable, that's a separate statute and information. This, yeah. Checking ID would not be in the rule package that we're discussing today, but if you need information on that, I'm happy to provide that to you after the meeting.
My perspective, I feel like you guys are pretty robust on resources that you provide us for education and very specific about how to do it, how to go about it, what is acceptable, what's not acceptable.
This is Jesse Bonnie with the CAO. I think it behooves me to also point out that generally speaking, the cannabis industry does a very, very good job maintaining with ID checking. The OLCC does regular minor decoy stings. We generally pass with over 90%. I think we're at like 93% compliance rate. And the implications of failure is quite severe. 3 failures in 2 years can lead to a cancellation of your license. So you are disallowed from continuing to operate for 3 violations, whether that's a minor decoy or otherwise. So licensees are generally very attentive to this, not saying everybody's perfect all the time, but it is. And I believe one of the requirements for ID checking is the physical inspection of the ID. You can't, it's not just you literally have to look at a physical ID.
Yeah, I would add that we will turn someone away who is obviously, they must have an ID. I had to send a guy back for his passport because he had a British Columbia from Canada. It's very well laid out, and I think that we'll probably held to a much higher standard than alcohol. And anyone in this business knows there's really 3 big rules, and this is not one you mess with. You can be fined and shut down in a hurry.
There's another thing is that minors are not allowed on the premises.
Yeah.
Right. So alcohol, that's a 5-year-old can walk into a liquor store with their parent. That could not happen in the cannabis industry. There's no actually age restriction on any alcohol premises where there's no sale or distribution of to consumer liquor. So like a 5-year-old could run around a distillery if they don't do sales. That again could not happen on cannabis premises. Minors are not allowed anywhere on the premises of the cannabis licensee. There is some exemptions for family, on like farms and stuff if you live on premises. But that's about it.
Required signage as well, clearly posted, multiple places, no minors allowed, very clear.
Anything else before we?
As far as we don't, if because the OLCC does provide education, it's not just education on what types of IDs are valid, but it's education on what does a fake ID look like. And so there's identification. We turn away people for having fake IDs. It's a very clear, very, very important mandate that our staff members are not admitting people who are underage.
We have 0 tolerance, and we let somebody go for the one time that they did. So do a minor decoy.
All right, everyone. Thank you so much for joining us today. Please let us know if you have any questions. And thank you for joining.
Thank you.
Thank you.
Thanks to those online as well. Thank you.
Thank you. Thank you.